Appeals is now in session for its regularly scheduled meeting of February 2nd, 2012. I'm Joey Hargis, and I'll be presenting the cases for review in today's public hearing. At this time, I would ask everyone to either silence or turn off their cell phones so as not to interrupt today's meeting. The board would appreciate it. The procedure will be to introduce the case record as the Codes Department has it on the wall here, and the monitors there behind you by means of a PowerPoint presentation. We'll present any maps, plans, photographs, and sketches involving today's cases. We'll also present any letters that we've received in support or opposition to a case, as well as any correspondence from other government agencies. After the Codes Department goes first, the applicant will come first to the table here. As you see, the microphone in front of me has a little red ring. There's a button on the table that says speak. If you'll hit that, the light will come on. Once the light's on, your mic is hot, you're ready to talk. When you get done speaking, please, if you would, please hit the button. The board in their rules, the applicant will go first. If there's opposition, the opposition will come up next. And then after the opposition has had their time, the applicant will have a period for rebuttal. In the board's rules, in cases without opposition, applicants have 10 minutes to present their testimony. To the right of where you're sitting is a clock that has your time. The clock will run once you begin your testimony, but will stop for any questions that the board might have of you. In the event of a case with opposition, each side of the case, both the applicant and opposition, have 15 minutes in total to present that testimony, and that is not a per-person thing. So if you have multiple folks that need to speak, please work out your times before you come up here and divide your 15 minutes accordingly. All section numbers I referred to today come directly from the Metropolitan Code of Law, which is Title 17 of the Metro Code, and applies to the entire jurisdiction of the metropolitan government. It was adopted with an effective date of January 1st, 1998 by the Metro Council, and I'll dispense from reading individual sections of the code unless the appellant or opposition requests that I read those sections. The code is here at the podium, and I make it a part of the record now. The code requires that this proceedings be taped. Therefore, it's imperative anyone wishing to address the board, please come forward, have a seat, identify yourself, and make your presentation to the board. The board will go through all cases set for public hearing today, and then after each case, the board will then discuss on and vote on that case. The board is vested with the power to act on the cases before us as outlined in Section 1740-180 of the Metro Code of Law. The code requires that 4 members of this 7-member board be present to constitute a quorum. The code also requires that you have 4 affirmative votes to grant your application. Today I have 5 members present, so you need 4 of these 5 individuals to vote for your case to approve you. If you fail to get 4 of those votes, and we end up with a voting situation of 3-2 or 2-3, that case will stay on the agenda for the next 30 days. So that case will come up again at our next meeting on February the 16th. And then after February 16th, if none of those members have changed their vote, or the 2 members who are not present have not watched the record and become eligible, that case will be deemed denied by operation of law. The applicant or any aggrieved party may request a rehearing within 60 days of today's public hearing. Further, any applicant or aggrieved property owner may appeal this board's decision to Chancery or Circuit Court within that same 60-day period. But after that 60 days has elapsed, the board's decision is final and no further action can be taken. If you're an applicant and your case is granted, it is necessary for you to come and pick up the permit for which you've applied. It should be noted you have 2 years from today's date to pick up your permit. If you fail to get your permit within 2 years, you have to come back and seek approval from this board again. Mr. Chairman, I submit that all cases were filed in order. Applicants notified by certified mail as required by the zoning code. All affected property owners within 300 feet were mailed a first-class letter, and a legal ad was published in the Tennessean as required by the code. And before we begin today, the board allows elected officials to address the board should they wish to before public hearings begin. And I'll call now if there are any elected officials who'd like to address the board. Come forward, please.
Look that over. I'm lost.
Give me 1 second, sir. I'll be right with you.
Good afternoon. My name is Emily Evans. I am the Metro Council District 23 representative. And I'm here on a special exception application that's being made by Harding Academy for their campus at 170 Windsor Drive in the 23rd District, and actually in my neighborhood down the street. The school is essentially reshuffling their campus and moving some buildings around. There's no increase in enrollment. There's no change to the traffic patterns. And as a result, I'm here in support of their application. To get to this point, we have had a number of years of working together as a community and as a school on parking-related matters, on crowd control, on use and activities in the community to great effect, which is why we're able to be here today. Ian Craig, who is the headmaster at Harding, has, I think, done just a terrific job reaching out to the community, communicating, working cooperatively on things like parking in areas that both the school and the neighborhood had deemed potentially dangerous to particularly small children. In advance of this application, they reached out to me almost immediately after deciding to submit, and we met. We also have had meetings within the neighborhood. We had a meeting at Harding Academy that included both the Belmead Links neighborhood, the Belmead Terrace condominiums, and Boxcroft, which is essentially all the adjoining residential areas around the school. So they're going to present their plan. I hope you'll give it due consideration. I think it conforms with the zoning code and certainly with the spirit of cooperation that we now find ourselves in. Thank you very much.
Thank you, Council Lady.
Thank you. Good afternoon. My name is Walter Hunt. I'm the councilman for District 3, home on the Fontanelle and a few other things we're building out there. I wanted to address the board about this because it's kind of unusual situation. The Fontanelle owns a building that they're going to eventually put a barbecue stand in it. So it's facing, when you come down on Hickory Boulevard, you see the back of the building, and they painted some letters on there saying Fontanelle and barbecue coming up. And I've seen it, but it didn't bother me because I've seen painted on buildings all over Nashville. I was born and raised here, and I didn't see anything different about that. Then all of a sudden I got this call about the fact that it was being referred to as a billboard. Now, when that came up, they put the signs out, BZA signs, appellate signs, and it had billboards. And that created a firestorm. And I've been getting calls for the last week because people are thinking it's going to be a billboard, like Lamar, high up in the air, and I've had to tell them, no, it's not a billboard. Well, they put it as a billboard, so I couldn't explain all that. So the only thing I had to do is give them Webster's definition of a billboard, which is not paint on a building. So, I don't think it's a big issue. We were talking about the various distance from residential property. There are no houses on the side of the Hickory Boulevard where the building is. With the tree line, you can't even see the signs on the side of the building because, as I said, the area where I am is pretty much rural anyway. It's just not a distraction. It's real quiet. I mean, I was surprised to see it even come up, to be honest with you. So I asked this board to consider where it is. Nobody's complaining about it. They complaining about the billboard, and I'm saying it's not going to be a billboard. It's paint on the side of a building, and that's what I spent my whole week explaining that. So I just felt that it borderlines some things that we may need to clean up. We may need, and it may be right by putting paint on the side of the building, but I think we need to call it something else instead of a billboard. That's all I'm saying. So if you see fit to go ahead and approve this, I would appreciate it. It's not a big deal. It's very small, and I ask your indulgence to approve it, and I appreciate your time.
Councilman Hunt, I do have a question about this, and
Yes.
I know you've been here, or Fontenelle has been here before with this particular, and you've, I know, talked to a lot of people out in the North Nashville area. Is this something that will happen again with a building or an outbuilding out there? Is this some machination that Fontenelle wants to put their name on a lot of things going out there, or is this just one isolated incident that won't happen again if we allow them to keep this on the side of a building?
Oh, this is an isolated one-time only. Now, there are some signage that we're discussing, but nothing like what we're talking about now. Matter of fact, I've already talked to codes about it to make sure that I can tell them exactly what we can put there, and this is on site, on premises. The other one we're talking about is not on site, okay? So what we're doing now is that I'm getting all the information that they need. I've already seen pictures of the signs, and I've talked to the people in the planning commission, so we know enough information to guide them, keep them linked. There won't be any digital signs, yeah, nothing like that, and there won't be any.
But they don't have any plans to put any other signs up here anywhere on the site like this or paint?
Oh, no,
Okay.
no, oh, no. That's a real unique circumstances, and, you know, I never would have thought it got to where it is, but
Okay,
that
thank you.
won't be happening again. They only got one building.
Councilman,
Yes.
of all the phone calls you got, has anybody got a problem with the actual words on the sign, or all of them are about some billboard, right? I mean,
Yes.
nobody minds this wall, right?
Nobody has a problem with that at all. They just thought they were going to have a Lamar billboard sign sitting
Okay.
50 feet up in the air. And I said, no, that's not going to happen. You know,
Okay.
so,
Thank you.
thank you.
Just out of curiosity, what definition did you find in the dictionary?
Oh, I'm glad you asked that. A billboard is a sign anchored in concrete on a pole that's 40 feet, 50 feet in the air. Not paint on the side of a building. And so that's how I was explaining to the resident that called me. I said, no, it's going to be paint on the side of a building, not a billboard. And I appreciate your time. Okay?
Councilman, did you wish to speak?
I'm sorry, you may need to punch your button.
Go ahead. Sorry, rookie mistake. Good afternoon, distinguished members of this board. I am Scott Davis. I am the 5th District Councilman from Metro Davidson County. And I've been in front of this board before, and it's very rare for me to speak in favor. I always keep an open mind and always judge both sides. But when I come to a decision that I support these two matters in District 5 in front of you today, that's something to remember, because I do not at always come forward to this board to let you know that I'm in favor of something. But I will always come and speak the truth to the best of my knowledge. That I promise you. And the first matter concerning the corner of Cleveland and Lischey, the urban housing solutions, I am in full support of this. They've had several meetings in the neighborhood. They called an extra meeting at the request of the board last week, and the neighborhood's in Fair McFerrin Park leadership, Cleveland Park leadership, and I believe that the board has received some letters of support. I had to come here in person to let you know that I am in support of this also. And I just want to thank you for your help, and I want to thank Urban Housing Solutions for its support for my community. Moving on to the second matter, on McFerrin with the pharmacy, I'm in full support. Please grant this variance. There's been a lot of great business development in my district, and I am definitely out there to help the small businessman, but also be aware I am sympathetic to the needs of the other property owner, and I'm praying that something can get worked out today. However, though, past this variance, I'm in very much support of this. And I thank you for your time, and I would like, if there's some time later, to speak in favor further of this variance. Thank you.
Thank you very much.
Councilman. Any other elected officials wish to address the board before we get started? Okay, Mr. Chairman, seeing none, the board has a consent agenda. Before the meeting, a board member reviews the record in each case prior to today's public hearing, and if, in their opinion, the applicant meets the criteria for the application they've requested, and they feel that testimony in case would not alter the material facts, they recommend that case to the remainder of the board for approval. Today, Mr. David Taylor reviewed the consent agenda and has recommended the following cases for approval. If you're here on a case that I call and you're here in opposition, please raise your hand. Let me see you. And then we'll pull that off the consent agenda and put it back in the regular order for today. The first case recommended for the consent agenda is case on page 1, case 2012-005, the St. Pishoy Coptic Orthodox Church, requesting this one on our docket. The setback variances were approved at the last hearing. The applicant submitted elevations showing the height proposed, and the irregular shape of the lot is the hardship on, and narrowness is the hardship on the case. Is there anyone here in opposition to case 2012-005? Mr. Chairman, seeing none, this, again, the narrowness of the lot and the irregular shape is the hardship here. The next case recommended for consent, case 2000, at the top of page 3, case 2012-12, Fontanelle is the applicant, Goobers Roadhouse LLC, the owner of the property located at 4421 Whites Creek Pike, requesting a variance in the distance from residential to allow the legal use of a type 1 billboard. Just to clarify, expand on the council member's comments, the zoning code actually refers to off-premise signage as a billboard in the definitions from the zoning code. It's not in, this one is not in the traditional sense when you think of a billboard, but our code defines it as such, and that's why we've listed it as that. Is there any parties present opposed to case 2012-12? Mr. Chairman, seeing none, the irregular shape of the property is the hardship here and necessitates the need for variance. And then finally, again on page 3, case 2012-13, Urban Housing Solutions is the applicant, Mr. Johnny Willis, the owner of the property at 900 Leashy Avenue, requesting a special exception in the CL district to allow the construction of a new 2-story apartment building. Is anyone here in opposition to case 13? Present. Mr. Chairman, seeing none, this is a special exception under the zoning code for setback and skyplane. There is a small portion, approximately about the size of this podium, that is penetrating into the skyplane, and the overall proposal has a recommendation of approval from the Planning Commission. And with that, Mr. Taylor recommends cases 13, 12, and case 5 to the consent agenda.
Okay, so we've got a motion made. Do we have a second? All in favor? Any opposed? Passes.
All right. If you're here for cases 5, 12, and 13, your cases have been approved. You are free to go. Please follow up with the Codes Department beginning on Monday and to discuss your permit. Thank you. Mr. Chairman, if you'll give me just a moment, we'll get started with the first case today. Chairman, we'll call the first case, case 2008-077. Councilman Darren Jernigan is the appellant, MED Properties LLC, the owner of the parcel, which you see here located in red at 1200 Bryan Street. He's requesting an item A appeal in the IR district to appeal the zoning administrator's determination as to use of the property at 1200 Bryan as medium manufacturing. There is a bit of a background with this case. As you'll notice, the case year listed as 2008. Typically, the zoning administrator would go first and explain the appeal. This case is actually heard prior to the board. This is a new public hearing for you all. Several of the members were not present at the prior meeting. This case, to give you a little procedural background, at least briefly, and I'll turn it over to Brooke Fox from Metro Legal to cover one. But in 2008, the Board of Zoning Appeals, based upon an appeal by the councilman, ruled that the operation that occurs out here as a pallet factory was a use as heavy manufacturing. That definition and interpretation was appealed to court at such time the applicants appealed that determination by the board as heavy. Bear with me one second. I'm trying to get your...
Which court did it go to, Joey?
Brooke, that was Chancery Court. Hopefully I've got something, an image coming to the screens in front of you. I don't. I'll get that worked on here at the break. We'll get some of the tech support to get us the monitors in front of you working. So I apologize for having to turn around here. This is the subject property that you see here on Bryan Street. It is zoned IR. This is an aerial photograph of the property in February of 2011, showing the existing property here. The property boundary runs along this portion where my cursor is falling. This is a NES substation, which is on the south portion of the property. The manufacturing occurs here in the storage of pallets on the north end of the property. And I'm going to leave this screen. I'll come back to this screen, Brooke, for you all to cover. But this is as the subject property looked upon my visit, posting the signs. At the property out there. These are views along Bryan Street, looking north in the bottom right-hand photograph. Then moving around the site to the north, this view is from the north of the property, the storage area of the pallets on the north end. Views looking south. Okay, Mr. Chairman, I turn this case over now to Brooke Fox, who will be representing Metro. Mr. Fox will have 15 minutes to present sort of our side, from the Metro point of view, along with any other parties he wishes to bring up there.
Hello, I'm Brooke Fox, and with Metro Legal, and also opposing counsel here is Chuck Welch. We're really bringing this case jointly before the Board of Zoning Appeals. This is really a settlement approval, and the BZA is my client, so once we're in Chancery Court, I can't just sign a piece of paper and say, yep, the BZA is going to agree to this settlement. Instead, it has to be something that we bring to the BZA and get the BZA's approval. And then hopefully, if the BZA does approve, we'll have a BZA order, then we can present that to Chancery Court and explain to Chancellor Perkins the case has been resolved. Councilman Jernigan has tirelessly worked with the parties on site and through other communications to try to come to a resolution. The difficult thing here was to try to quantify these stacks of pallets and try to determine where's a way to measure that could be reasonably be inspected to keep them above or below a line of what is perhaps dangerous in the way of flammable or is perhaps unsightly and rises to the level of heavy manufacturing versus medium manufacturing. So what we finally came up with, instead of trying to count 20,000, 40,000 different pallets or count 25-foot high or 30-foot high pallets at some point that sometimes perhaps allegedly were falling over, Instead, we arose at this idea, and I forget whose idea it actually was, but we've all agreed that it's a good idea, is to have a 12-foot opaque fence around the property and then have it, instead of the pallets sneak above the height of the fence up to 25 feet, instead they won't go above the height of the fence. That way, even from the codes inspector's perspective, if they're driving by, they can almost do a drive-by inspection to see if they're within those parameters. If they are, then the BZA would consider it medium manufacturing. Codes would consider it medium manufacturing. It doesn't rise to the level of such a problem that it branches into heavy manufacturing. So that's where we are. That's the settlement approval. Do you have anything to add? This is opposing counsel, Mr. Chuck Welch.
Thank you, Mr. Chairman, members of the board. Actually, the fence, and I see up here that it's noted as a wooden fence, and that's the agreement. It'll be a wooden fence, more in keeping with a residential area, which I think has been most of the problem these many years. With the exception of the gates that will be, that have to be commercial grade chain link gates. But other than that, it'll be a wooden fence that you would see in a residential neighborhood.
So I think this is going to be a workable solution for the pallet factory on the one hand, but also for the BZA and for the codes so that this case won't keep coming back before you. It was originally before the BZA in 2003, and maybe even before that. So hopefully this will be a long-term resolution. So with that, we request your approval.
Yeah, I wasn't here for the 2003 case. Chris, were you here for the old case? You know, it came down to, of course, a lot of these were stacked high, and there were a lot of these pallets on site. So it sounds like you all have agreed to the fence being the high water mark of the pallets. They won't be stacked higher, and that basically the what's the other one? Oh, this would permit the, so you all didn't get into the number of pallets, it's just the height of the stacks?
No, and the reason we batted that around for a year or so and trying to figure out a way to have that work, and we could not figure out a way to have it work from the pallet factory side, but also from codes inspector sides too. It had to count.
Right, sure.
So this felt like an easier way for both sides to keep track of, is this going to be offensive to the BZA or not? Is this going to be heavy manufacturing or medium manufacturing? So the thought was, if it's below the fence line, 12 feet, then that's medium manufacturing.
Because I think that's what the cause was, and we'll hear from the councilman when he comes up here to talk about it, that the neighbors did not like the kind of unsightly height of these, and they were allegedly falling over, and, you know, they were just, it looked like something more than just medium manufacturing. And so I think a fence will go a long way, and particularly if you don't stack these so high. I remember asking someone from the pallet company that time, well, why don't you put them in shorter stacks? And they said something like, well, we'd have to hire another forklift operator or something like that. So, you know, it seems to me that this is a workable solution for the neighbors around, so they won't see these and they won't fall over or things like that if they stack too high. So you all, it sounds like you all are total in agreement of these rules up here, and you're just asking us to ratify that, and you'll go back to court.
Yes, we're here jointly.
Okay, that'd be wonderful.
Oh, first Councilman Turgeon wants to say.
Thank you. I'll make sure the order and how we're doing things.
We'll get,
Press the-
I got him. I got you.
You got it?
Yes.
Okay. Perfect.
There we go. This has been, for me, a little over 4 years, and I'm happy to bring this to an end. About 2 years ago, when you're asking where the idea came from, I did create legislation through the council, an ordinance. It did not apply to here because of, I did it after the fact. But I did it to where if you're having manufacturing in a neighborhood, that you would have a fence, and whatever the storage is cannot go above that fence. That really dictates how much you can have depending on the area that you have. So that seemed to me the best way, and we did pass that in the council 2 years ago. So that's kind of where we got the idea to try to use this. The 12-foot fence, obviously being wooden, going around, it's very easy for codes to come out and stand there and look to see if it's above there or not. So I'm happy to bring this to a close. And we were agreeable, and I'm pleased with that. But if there's any questions, I'd be happy to answer those. But I think that you've done that with opposing counsel.
I do have a question that
Sure.
I'll ask the two lawyers when they come back in front of us. Obviously, the fence will go around the entire property. What about, there will be some sort of gate, and will that be open? Will that be open and closed? But how the trucks get
I believe it's an
inside?
industrial gate that slides back and forth.
And so that'll be 12 feet and covered, and so.
And, we didn't discuss whether there'd be a green windshield over that or not, but
Well, not behind the gate, but basically
But on the
that
gate,
will
but on
block
the gate.
the view.
would that,
Be some kind of cover.
yeah, there'll be some kind of cover on the gate.
Okay.
That'd be fine. Thank you. I didn't.
I have a question. Does the difference between the heavy manufacturing and medium and light, is that somehow governed by the fire code as well?
Well, it came down to when we first, in 2003, it was deemed medium manufacturing. And at that time, I believe it probably was. When I brought it back up in 2008, I guess the pallet business was doing well, or not well, depending on whether you want pallets out of there. But it was stacked up, and it doubled, if not tripled, in size. So I asked the zoning administrator to come back out and say, is this still indeed medium manufacturing? He said it was. I disagreed, so we appealed it. Under heavy manufacturing, it does mention large amounts of lumber, and this is what this was. And we did have, at the time in 2008, testimony from the fire department, but it basically dealt with if you had large amounts of highly flammable material. And obviously lumber is flammable material. And there were 2 propane tanks next to the lumber. So we've worked all that out. And so now we believe that bringing it down to this level and keeping it at this level, as long as they stay below the fence line, that would easily, we think, fit within the definition of medium manufacturing. And David remembers, I think, maybe the chairman remembers that it was very technical issues from down to Webster's Dictionary to codes and ordinances, and we were there for 2 hours trying to figure out what to do. And we still didn't come out with a great resolution, but through the court system and working together over 4 years, it was one of the first things that I did my first term. And I'd be happy to get this under our belt.
Oh, it's a great solution, Councilman. Congratulations. I might just hear from opposition. I mean, unless anybody else has questions.
Yes, you
Great.
should, absolutely.
Thank
Well,
you.
they may-
It's across the
Are they
street.
through with their presentation? If they still have some rebuttal time, if they would.
Exactly. They have 11:28 of rebuttal, so.
Yeah, Mr. Chairman, then the only person eligible for rebuttal is the councilman in this case. He is the appellant.
I'm the applicant.
He's the applicant in this case.
I'm sorry.
Bruce Fox and them were essentially sitting in where the zoning administrator would have normally gone first.
But we can call them back if we had a
You
question.
can always
if we
call them
wanted to.
back, but for rebuttal purposes.
I'm sorry. Who is the individual who raised their hand in opposition?
Yeah, now,
Does he have standing?
yes, he does.
Oh.
Yes.
He's a homeowner across the street.
Remember, in the item A appeals, we sometimes have 3 or 4 parties involved here.
Right. So I'm trying to move to there.
No problem.
Okay. If I may be dismissed, are there any more questions? Thank you.
And Mr. Chairman, this gentleman's giving me some photographs. I'm trying to get those displayed to you.
Some of them are not real good. They were taken at dusk, but some of them will make my point. My name is David Atchison. I live at 1101 Bryan Street, which is directly across from their northeast corner, so I have full view of their storage area. I filed the original complaint in 2004, I believe it was. A couple of things I'd like to comment on that Councilman Jernigan brought up. One was about, I believe it was Mr. King had mentioned something about what made why was the determination made that this was medium rather than heavy manufacturing. And that had been our point of contention all along, that it was heavy manufacturing by definition. And in the first hearing, that was totally ignored completely. This was not the board, the Zoning Appeals Board, that heard that. My lack of funds and lack of a cooperating councilman at the time kept us from taking it onward at that time. But by definition, at 170460, plainly states, typical heavy manufacturing uses include, though not just limited to, but they do include wood or lumber processing, and that is what they do. They're not simply a storage facility. They take pre-cut pieces, and from those they make pallets, and that is a process. Now, determine on which particular set of plans you see from them. Their building in the back by the propane tanks are either a kiln, which is what it says it is in the electrical permit, which is used to get as much moisture out of the wood so to stop its shrinkage. Or if it's chemical, then it was never, why would we not inspect something that's putting harmful chemicals in an area, which was never done. Okay, as far as the fence part, I'm hoping they're only speaking of the fences around the dock area rather than in the storage area. Because in 2004, when they went in and increased the depth of their property to allow them to put more pallets in the same amount of space, excuse me, it's small writing, I'll have to take my glasses off to see it. It stated in, I believe it was 2004-0065-A, and one of the restrictions on there was vehicles, as far as the storage area, vehicles blocked by some type of solid barrier. It wasn't then, it never has been, it's not this morning. Some of the pictures that I gave to him show that quite plainly. They're the plain ones. The other ones are the ones that aren't so plain, but they show multiple types of different trucks. They swing those gates open, and in they go. Sometimes they load them, unload them, get them out. Sometimes they sit there all night. We've got one now that's been sitting there for 3 days. Problem being there is, besides my contention still, there's heavy manufacturing because of definition. And these are straight from the Metro codes. I didn't make them up. They still have things here that unless they don't bother to update them completely, they have inspections that's never been completed. Final inspections on their updates. I can't understand that. I'm sorry, forgive me. But, yeah, that's one that called the 600 square foot foundation pad for pallet stabilization equipment. Yet the electrical permit, that's on CACF 2006-22719, calls it pallet stabilization. But on the electrical permit, let me get the number of it. In here somewhere. I forgot to staple them, which didn't help. Basically, it was basically the same time. Plainly states that other item is 160 amp, 480 volt, 3-phase kiln. Construct concrete foundation pad for pallet stabilizer equipment. So, again, if you're heat treating lumber, it's a process. And you had brought that up about what made people decide. Fact is, they didn't want to hear anything in 2000 when this was originally brought up. Everything I said, I documented, was ignored. I had backup. They didn't want to hear it.
Sir, can I ask a question?
Yes.
The city's been litigating this matter for what must have been
Years.
8 years.
Yes.
And our council's here advising us that it's medium manufacturing. Is it your position that the city ought to continue to litigate this matter?
I think the city needs to take the laws they have written and abide by them. And this law plainly states they do not need to be there.
Well, there's a dispute over that. There's another side, and there's litigation for 8 years, and the city has been defending this position for a while. I guess my question is, would it be your suggestion that the city continue to litigate this?
Let me qualify that. Councilman Jernigan, when he was elected, he told me he would look into it. He felt if it deserved further, he would take it further, and he has done that. I think sometimes to the detriment of other business. Okay, and I understand that this has been a negotiated agreement. Mm-hmm. My problem with that is, and history has shown us, that on this company's site. I've turned them in, Councilman Jerniman's turned them in over the gates. They want to put gates in that storage area, plainly states. No vehicles except tow motor. Tow motor accesses through the building, through their internal, because tow motors are not licensed to drive on the street. They'd have no reason to have a gate on the storage side, except for their convenience, but yet it's here and they continually ignore it.
I guess I would ask you, is your opposition to this based on some contention that you want to see an enforcement of the code, or is this particular property a detriment to you personally or to your home or whatever?
Sir, it's a detriment to all the property around there. No one can sell a home except to a flipper in that immediate area. Okay, I try to get the people that are renting their home at 12th and Bryan Street directly across from their entrance to their storage area, their outside entrance to their storage area. I tried to get them to come today, and he said, I rent it, In other words, he has no interest, immediate interest in it now, and he didn't, he's dropped his involvement. Another that was there, he can no longer speak for the problems it causes. He died of cancer with his lungs full of sawdust. But yet every inspection, they find no problems, if they even come out. Previous employees there who did not know that I knew them, I had some conversations with them when they got a call. The next day, he spent the day cleaning the stuff up for the inspection. I'll leave that at that.
Okay.
If we could get it, if they will enforce the laws. Okay, I don't want to see them throw away probably $1 million worth of things. Granted, they shouldn't be there. I'll never change my contention that they're heavy manufacturing by definition in our own zoning laws. Okay. I tried to be good neighbors. I was assaulted by their manager. Okay, and I'm disabled. He came very close to breaking my neck.
Well, we're not here to kind of cast aspersions on.
But that's my whole point. The law, if it applies to one, it applies to everybody. If it doesn't, what good is the law? That's my whole contention. Do I support the negotiation? No. Do I appreciate what Darren Jernigan has done? Yes. Because I know Metro Legal is pushing him to settle this. Okay. It's very obvious. I spoke to the original person that wrote the thing that specified typical heavy manufacturing uses include, but are not limited to, and it says wood and lumber processing. I asked him specifically. I knew him from years ago. I said, Melvin, why did you put it like that? He said, so something like this couldn't move in on a neighborhood. I said, well, it did.
Sir, I admire your zeal and I respect your right to speak, but what you're asking this board to do is ignore the advice of the councilman who speaks for the entire neighborhood. Ignore our attorney who's telling us it's medium manufacturing. That would take a lot for this board to do. I mean,
exactly. All I really ask if some type of something in the negotiation could ensure prompt inspections of complaints without forewarning them. Some of those pictures that I gave him are there's one right there. Well, that one's sideways. If you cock your head to the left, now that one's straight up. There's supposed to be a solid barrier to keep any vehicular traffic out of that area. I had to call the police one night because I will not go on their property. I will not touch their property. I had to call the police one night to come out there because they left those gates open. 11:30 at night. Those gates were wide open. That's some of their storage. Okay.
yeah.
And nothing. And I understand y'all. You have to rule one way or another. Don't take me wrong. All I'm saying is, if we must have a negotiated settlement, I would like to see a negotiated settlement that will be enforced, because everything in the past has not been.
Okay, let's say I agreed to do what you're saying. What you'd be asking us to do is approve the settlement and then ask codes to enforce the law. They're charged with enforcing the law. Nothing these 5 people are going to say is going to increase that at all. I mean, they are charged, they are the enforcement wing, and they are charged
Exactly.
with doing it. So they're going to do it. I mean, they're going to do it to the best of their abilities.
In a perfect world, yes, sir. I'll leave it at that. I mean.
Okay. All right. Duly noted. Thank you.
I'll leave it at that.
All right.
Thank you for hearing me. Again, I know y'all have taken on a difficult task and spent a long time on it.
Thank you very much. Attorneys, you have the right to rebut if you would like to.
And I would like to ask the Metro Legal attorney, Mr. Fox, to kind of walk us through the timeline of where this case has been and what happened.
All right, first, I take issue with the gentleman's assertion that Metro Legal is pushing the settlement. If that is the way it's coming across, let me step back, because I don't want to push the settlement. We can take this case to trial if need be, but the councilman and working with the neighborhood group and with the pallet factory spent a lot of time to work this out. The issue comes down to an interpretation. It's basically whether or not the pallets there as stacked in the past was highly flammable. It had gotten to a point over the years where it was starting to be perhaps a problem in this board's opinion, to the point where it's highly flammable, elevating it to heavy manufacturing. With these rules now in place, if this is approved for the 12-foot fence, and the stacks won't be above that, so 12-foot high, it's what we're asking is, and I am recommending that it essentially be the board's interpretation that that's not highly flammable, toxic matter or explosive materials that would elevate it out of medium manufacturing and put it into heavy manufacturing, that is suitable for medium manufacturing. So that's the settlement. Now, I've lost track of what the question was put to me, Mr. Ewing.
Timeline of all of this. When did you get it, and what's been going on with the court?
Let's see. The case came originally in 2008. It was filed in 2008. And then over the course of the past 4 years, there were different chances for a resolution of the case through perhaps the purchase of or selling of the property by the property owner, things of that nature. So the case in Chancery Court was held in abeyance for different periods of time as opportunities like that were explored. In the meantime, opposing counsel and I were battling out discovery issues and that kind of thing. The opportunities such as selling the property evidently never materialized, and I can't put them in a situation where they can force them to sell it. So instead, Councilman Jernigan was able to help negotiate this deal. I mentioned that in 2003, it had originally come before this board. The litigation started, though, in 2008, I believe. But it had originally been before this board in 2003. That's when it was had been a problem back then.
That was really the basis for my question about the height of the material, because based on the experiences that I've had, if it's a high stack material, would have some fire code ramifications, and that's why I was asking to ensure that if this board grants your variance request, that we're not trying to circumvent some life safety code or the fire code.
No.
So that was my whole point there.
Right. There'll still be need to meet all other governmental approvals, whether they be code, health safety issues. We feel like this, though, is going to be something that the fire marshal will approve, because in the past, again, the fire marshal has paralleled this board's interest, that the problem was the 25-foot high stacks and perhaps falling over and that kind of thing.
Commissioner King, I think the fire department actually approved it up to 15 feet, and so this is less than what they require. I'd also like to point out that, just for the record, that wood processing was squarely an issue in the 2008 case. This board found that it was not wood processing, that it was assemblage. Also, the kiln that Mr. Atchison mentioned is really a sanitizer. That was squarely an issue before this board in the 2008 hearing, and this board found that it was satisfactory and met all the requirements.
And that didn't cause a problem because the kiln only raised the temperature to 150, 180 degrees.
I think it's less than 200 degrees.
Nowhere near to the point where it would set the wood to flame. And then the dried wood that results then is put on the trucks and then taken off within 24 hours. So the stacks that are around are not the dried result. This is pre-kiln wood that's stacked there. So this board had already found that the kiln and those stacks are not a problem.
Thank you.
Yeah.
Do we have any questions? Okay, then I'm going to close the public hearing. And I'm going to be bold enough to make a motion that, based on the advice of our council and the wishes of the council person, that we find this is medium manufacturing and that we approve the 12-foot opaque fence and insist that they keep the pallets under 12 feet. And in fact, I would almost defer to council to provide some type of settlement agreement, which will approve.
That's what we had planned to do.
Yep.
Okay. I will second it, and I would like to add that we are also finding that the wood is not highly flammable here.
Fair enough. Okay, all in favor?
Aye.
Any opposed? Good, passes.
Thank you very much.
Thank you, Mr. Chairman, members of the committee.
Okay, Mr. Chairman, we'll call the next case, case 2012-10, OIC Granny White Townhomes, the appellant owner of the property at 1200B Grandview Drive, requesting a variance in the height provisions in R10 to construct a 360-square-foot detached garage. Referred to the board under section 1712-060B. The applicant has alleged the board would have jurisdiction under section 1740-180, item B. The applicant's here. Is there any opposition present to case 10? Mr. Chairman, seeing none, gentleman will have 10 minutes to present. But before he begins, let me go through our case record first. The subject property you see here is at the northwest margin of Grandview and Granny White Pike. It is in the R10 district. The red footprints, which you'll see here, won't be picked up in the aerial photo, but there's been a new construction on the lot that has occurred. The gentleman's request is to construct a detached garage to the rear of the site, which you'll see in the photographs is actually across a creek that bisects this parcel here. And the garage would be located toward the rear of the site here. Again, showing the home, the creek, which you'll see in the photographs, and then the proposed garage here. The maximum height allowed for a detached garage in this zone district, and based upon the size of the lot, is 16 feet. That is measured to the peak of the roof. From here to grade level, the gentleman's proposing a 20-foot elevation height. I believe the applicant submitted a elevation revision, which will make a part of the record. It may not be reflected here. This is looking at the subject property upon the visit to the site and the adjoining properties to the west. And just to the rear of the site along this tree line you'll see here is a creek that comes through the property, and the proposed garage, I'm not sure you can pick it up, there are stakes. The applicant staked out the corners of the proposed garage would sit here.
Can you go back and show the picture of the garage?
Sure.
Okay. And are those car doors? I mean, sorry.
Here?
Yes.
Yes, sir. This would be the garage door.
Oh, okay.
Opens.
I mean, but would a car go into those?
Yes, sir. It's
Oh, okay.
Yeah, the floor plan shows a one-car, essentially a one-car width.
Okay.
In there.
Okay, Joey, I have one question for you, just out of curiosity.
Sure.
How do they, they're not showing any pavement plan here, or how they're dealing with the creek. Is there a plan that may show that?
Not something that we have with us that they're addressing with us. They're tracked to stormwater as a part of the permit.
Okay, so
and
they
we let
take care of
them,
that way.
We let them handle that
Okay.
downstairs. This would be the proposed location of that garage.
Great. If you can introduce yourself, if you have 10 minutes.
Thanks, Mr. Chairman, ladies and gentlemen of the board. Joey, do you mind leaving that right there? My name is John Brittle. I'm a real estate broker at Village Real Estate. I represent the developer, and now for this matter, I represent the buyer of the property, a young couple who are buying this house. That, Ms. Jones, there was already a driveway cut there. You could almost see it. And they'll have a footbridge from their house over to their garage. It looks bigger on the plat than it really is. From the back of their deck to their garage is probably 25 feet. One of the reasons that we're here is because back on the plat, when we subdivided this lot, the line subdividing this previous lot ran east and west in front of Granny White. We spun it to a north-south configuration because of what Metro has determined to be a wet weather conveyance at the back. But when we did that subdivision, we lost a number of feet on the Granny White side, and so we didn't have room for the garage where we would really rather have put it. That garage door that looked kind of confusing is just a really pretty one-car garage door. To the north of us, to the right, there is a rental duplex with an out-of-state owner, and which is why I believe you don't have any opposition here. We've built a really nice-looking four-home development there, and that are smaller and meeting what the community is now looking for. And as you can see, we've matched the garage to the house really nicely. The hardships are that wet weather conveyance, the losing, we actually had property removed from our lot because Granny White's an artery, and then we also have a sewer line running back behind the wet weather conveyance. That the garage is 12 feet wide on the front, and at the back it's 8 feet wide, which is a stairwell going up to an office upstairs. And the other request for the variance is, as we are going to have an office upstairs or storage room, we're trying to avoid having a flat roof and meeting the 16-foot height. And so we have 8 in the garage and 8 feet at the peak upstairs. So that's the request.
So there's not a bathroom or anything in that upstairs area that would
No, sir.
make this look like an apartment?
No, sir, and no plumbing, in fact. Makes it look less like an apartment.
And then the mature tree line behind the house, is that impacted by the garage?
That's actually in the buffer around that water feature. We may lose some of the top right there, but no, sir, not planning on cutting any trees.
The height of this garage would not exceed the height of the house, or is it close?
That's correct. No, sir, I would have to say I don't know the exact height of that house, but it has 9-foot ceilings on the main and 9 feet upstairs. And I was there during the construction. It's taller than the garage. It may be taller only by 2 to 3 feet, but it is taller.
Okay, so if I'm translating this correctly, the reason for the height variance is because of the narrowness of the area in which you can build based upon the wet water conveyance and the easement, right?
Yes, sir.
Okay.
We would have put in the storage space behind the garage if we could.
Okay.
I don't have room.
Okay. Do we have any other questions? Okay, I'm going to close the public hearing. Discussion? Okay, then I'm going to offer up a motion that we grant the variance request based on the difficulties of the property with the wet water conveyance and the right-of-way, which limits the space in which they can build and therefore forces the greater height to kind of fulfill the purpose of the building.
I'll second it.
Second, so we've got
I'd like to add an amendment to that, if you would. That would be that the height of the garage could not exceed the height of the house.
that's fine by me. That's fine. Okay, as amended, we have a motion, we have a second. All in favor?
Aye.
Any opposed? Passes.
Thank you very much.
Joey, before we start this next case, I'd just like to make a statement for the benefit of the board. The appellant is Harding Academy. I used to be on the board of Harding Academy about 8 years ago. I used to have children at Harding Academy. I don't have a child there now. I have no financial interest in this project whatsoever. I am certain that I can hear this case objectively, and I'm certain that I can rule objectively, but I wanted everyone to know. And in fact, we've had a Harding Academy case before where I made this same speech, and I promise not to make it next time. Yes, let's take a 5-minute break.
Board stand in recess. We'll return shortly. Mr. Chairman, we'll call the next case. The next case is 2012-11 Harding Academy. The appellant and owner of the property is located at 170 Windsor Drive, requesting a special exception in the R10 district to construct 24,300 square feet worth of additions for Harding Academy. Of those, 21,300 is for a middle school. There's approximately 3,000 square feet for a band and drama addition. Referred to the board under section 1716-150 and 1716-040. The use is community education. The applicants are present. Is there any parties opposed present to case 11? Mr. Chairman, seeing none, we'll have 10 minutes to present. Let me get you all up to speed. The subject property is located on Windsor and Harding Place, the northwest corner of the intersection. You see the property bound in red here. This aerial photograph, and I'm going to stay here for just a moment. Harding came to the board most recently on this site to essentially construct what you see here with a gymnasium and a loop road that they've built around the campus. At that time, the zoning board approved a landscape variance along the northern property boundary in here for landscape standard A. I know there was some language in the Planning Commission staff report that talked about B buffers, but that's already been dealt with by this board. At that time, the board approved a site plan showing what you see here in the aerial photograph. Harding came to our office to apply for a permit. Such time I stated to them they would have to return to this board as a special exception to amend the plan that the board adopted. Their proposal is to construct additions in that synthetic field area, which you saw here. This area would be relocated into this area here. Demolitions will occur, and I'll talk about those in just a moment, but this is a zoomed up portion of their plan. The middle school addition would be located here, band and drama additions off the back of the existing theater, and the current middle school, which you see, would be located here is where the playground area would be relocated. For a brief period of about 2 months after construction, Harding will exceed FAR on the site. Our office is working with them, if approved here today, to allow the middle school kids who are currently on the campus to occupy the new structure, let school in, get all the kids off the property, and then the demolition would occur of the existing. So we'll phase the demolition and construction times so as not to create a panic on the site there. But this is a legacy subject property from the intersection at Harding Place into the campus site, and then views of surrounding properties. Starting in the upper left, this is across the street is the property owned by Harding at Kiever Park. The upper right photograph would be the view looking west along Harding Place toward Highway 70 and 100. Bottom left is toward the south, toward the Bellmead Country Club golf course, and then bottom right looking up Windsor facing north. These are the areas in which the addition will occur. The first photograph, and I apologize for the sun washed me out there pretty bad. This is where the 3,000 square foot addition would occur off the theater and drama area here. The middle school area would be constructed in this general vicinity on the lower photographs here. This wing, which you see in the photograph here, would be the portions of which that would be demolished after the subsequent construction. Those portions would come down. This synthetic field would be relocated onto that site there. It's going back to the overall proposed plan, would show the areas in which I was just looking at there. This comes before you as a special exception. This item deals with letter 6, and this would be a school that has a valid UNO under the zoning code prior to the adoption of this, and it comes before you as a general condition special exception subject to those items there. And with that, I'll turn over the appeal case to the applicants this time.
Thank you. If you could introduce yourselves, and you have 10 minutes.
Mr. Chairman, members of the board, my name is Tom White. I'm an attorney with Toone Intricate and White, and along with Chad White, we represent the applicant in this case, Harding Academy. Seated here with the table are Ian Craig, who's the head of school, Bear Dixon, the principal architect on the project, and Dan Barge, the principal engineer on the project. As mentioned by the staff, this is a special exception to build approximately 24,000 square feet. It's a new middle school with a fine arts building addition. The basic breakdown is about 21,000 square feet for the middle school and about 3,000 for the addition to the fine arts. I'd like to ask at the front end, in order to keep the comments to a minimum, we've asked the people that may answer questions that come up here. I would like to ask that members of the audience that are here in favor of Harding, if they would at least raise their hand for purposes of identification to the board. Thank you. We have submitted a position paper to the board, which contains a number of attached papers from persons with different disciplines, the architect, the engineer, and also the transportation expert. People are here that can answer any questions within those areas, but we tried to make it as concise as we could in the application. Harding's been in operation at this facility since 1971. They've previously been granted a special exception by this board, which has been mentioned. That was in 1999. Harding, in that prior occasion, was approved for a maximum of 500 students at this site. We are not asking for any increase in the students count. I think it's at 482, but there'll be no additional students under this request. There'll be no additional faculty, and significantly, there will be no difference in the current traffic patterns for the school. I wanted to mention at the outset, as did Council Lady Evans, one of the first things we did after the board approved this matter to go forward was we contacted Council Emily Evans. She could not have been any more responsive in listening to our request, evaluating it. She's been a huge factor in making the relationship between the neighborhood and this school as good as it is, and it's particularly good at the present time, as evidenced by the fact that there is no opposition here today. As a follow-up to that, we asked the Council Lady's support in identifying and having a meeting with smaller groups. She attended some of those, and I'm happy to say that the response was incredibly favorable, primarily because of the very good relationships between the school and the neighbors. We, at some point, were required, as this board's aware, to have a mandatory neighborhood meeting. We did that on January 16. Prior to that meeting, Ian Craig, the head of school, sent letters out giving a full explanation as to exactly what the proposal was, which is what you are hearing here today. And at that meeting, which was January 16 at the library at Harding, we had attendance from every neighborhood and group. Questions were asked. We had significant support there. And again, as evidenced by the lack of opposition today, there was great support within the community. The position paper, which I've given out in advance to the board, I'll just talk about the basic things that I think we need to demonstrate before the board. The first one is, as Joey Hargis mentioned, we're here pursuant to Section 17.16.040 of the Metro Zoning Ordinance. Harding has been approved for the 500 students. As I said, there's no proposed increase there. The indoor-outdoor interscholastic intramural activities are now all off campus. They're located at a park which has been approved by this board up at 9 Mile Hill. Excellent relationships there, which was clearly setting the precedent for the good relationship here. With respect to the key requirements under the code sections, first of all, the burden of proof's on Harding today. We realize that to demonstrate that we've complied with the regulations that are found in the Metropolitan Code. The number one and biggest item normally is the public health, safety, and welfare. That is, the plan has to be consistent with that. I don't think there's any question. Probably the best evidence we've got there is the lack of any opposition. But again, you've seen the letters from architect, engineer, and traffic consultant with respect to issues that this board would normally consider for health, safety, and welfare. The second major item is design and architectural compatibility. The language is the operation and physical characteristics of the special exception shall not adversely impact abutting properties, including those located across street frontages. Once again, I think the most telling thing there is the lack of opposition, but in addition, you have the letters from the three disciplines which I've mentioned previously. With respect to an issue that's always before this board, traffic impact, which is sub G. The applicant shall demonstrate how the proposed use will not adversely affect the safety and convenience of vehicular and pedestrian circulation in the area. Again, you've got a letter from RPM Transportation Consultants, Bobby Murphy, which addresses that. It was a relatively simple address because basically there's no increase in the students, there's no increase in vehicular count, and it's the same traffic pattern which was worked out so so successfully and has been so well embraced by the neighbors directly affected by it. With respect to other matters that this board would consider, I would mention that as the dialogue came between the school and some of the neighbors, there was a specific inquiry about whether or not there would be some pursuit of an SP or a specific plan rezoning on what's called the Kiever Park, which is that 4.2-acre park across the street. There was good interest by representatives of the school, good interest by the neighbors about trying to identify what specifically could be defined within that park as far as uses. That has absolutely nothing to do with the matter before the board today, but I wanted you to know that the relationship is good enough that that's an ongoing matter where the school is going to have two representatives to be a funnel to address those issues subject to board approval. The neighbors are very supportive. It's just symptomatic of the very good relationship exists between this school and this neighborhood. I wanted to suggest that this school has got an excellent reputation. They've been there since 1971, and the relationship only continues to get better as far as an educational opportunity for people that live in the Nashville area. I wanted to comment as well, you always receive a non-binding recommendation from the staff of the Planning Commission. I've received it, I reviewed it, as has Joey Hargis. It's totally supportive and recommends approval at the conclusion of the report. There's no negatives within that report. To my immediate right is Ian Craig, who's the head of the school. I'd like him to make a few comments and then reference to you that both the architect and the engineer are present. We'll answer any questions. We appreciate your courtesies. Ian, if I could ask you to address the board.
Thanks, Tom. Certainly, we've been here before in front of the BZA. The last time we were here was when, in the spirit of cooperation with 5 different neighborhood groups and in the support of our expanding programs, the hope that we'd be able to construct what is now a really beautiful 7-acre facility up on 9 Mile Hill. It's turned out to be a real success for our school, for the 5 neighborhood groups we worked so successfully with. In fact, at the conclusion, when we opened up and celebrated the opening of that facility, those neighborhood groups actually presented Harding with their Good Neighbor of the Year award, and so we're incredibly proud of that, and it is our most strict intent that this project would operate with the exact same spirit of cooperation and to the same mutually agreeable end. Thank you for your time. We appreciate it.
Mr. Chairman, that's our presentation.
Questions?
I want to commend you all for taking what is in the past been a very difficult situation with Harding Academy in the neighborhood and smoothing it over. And I think a lot of thanks needs to go to you and the council lady too, as far as this is concerned. I will echo what the headmaster said about the 9 Mile Hill project, which came in front of the board, and I was on at the time. The photos and the architect's renderings that we were presented, it looks better in person. I think you all did a great job, and that's a great addition to the area. I really can't emphasize enough, because we have lots of schools, universities, private schools that want to expand in residential areas, that it's not so easy. This is a 24,000 square feet additions. That's a lot, and for the fact that the neighbors are here, the council person's here, you all are here, I think that says a lot. And when another private school or another university calls and asks, how did you do it? Please explain to them our procedures. And this, I know this was not easy. It's not that you just show up here and everything's fine. There were a lot of meetings, a lot of the council ladies, I'm sure, talked to a lot of groups in the neighborhood. So I'm glad that you all ended up at this place right now, because it doesn't always work this way, as you know, Mr. White.
Thank you.
Any other questions? Okay, then I'm going to close the public hearing and discussion.
I would like to echo David's comments and commend the entire presentation. It sure makes it easier from this chair right here. I find support for it.
Okay. I am going to make a motion that, given the fact that all of the requirements of Metzo 17.16.150 have been met, that we grant approval of the special exception.
I'll second.
Second. All in favor? Aye. Any opposed? Passes.
Good luck.
As David Ewing commented, there's a significant number of people that we met with that did not come down because of the meetings, and I wanted to publicly thank them for the time they gave in the many neighborhood meetings. Thank you.
Sounds good.
This should be held in the highest esteem of how groups should work together, to collaborate in this community. I think you all have set a new bar.
But y'all don't have any chickens, do you?
As the council person said, chickens are permitted in Belmead. And Forest Hills as our great satellite cities of metropolitan Davidson County government.
Okay, Mr. Chairman, as the folks from the prior case depart, Mr. Chairman, I'll call the next case, case 2012-14. Mr. C. Sprinkman, the appellant and owner of the property located at 731 McFerrin Avenue, requesting a variance in the landscape buffer in the MUN, NHC, and UZO zone districts to use the restaurant on the premises without the required landscaping, referred to the board under section 17-24-230. The applicant has alleged the board would have jurisdiction under section 1740-180B. Is the applicant present? Yes. All right, applicant's here. Opposition present? I believe they are. Yes. Okay, both. Oh, I'm sorry. With that, is there any other opposition present? I know this gentleman, I've spoken with him prior. Any other parties opposed to the case here? None. Okay. The applicant will have 10 minutes to present their testimony to the board. If you'll come forward now, we'll give our presentation to the board first. The subject property is located in the MUN zone district. This is located at the southeast corner of McFerrin and Chickamauga Avenues. Over in East Nashville. This is the subject site you see here in red is zone MUN. The landscape buffer yard deals with the adjoining property to the east in this location in a landscape buffer standard. Again, the aerial photograph of the property. Yeah, I'm sorry. Landscape standard C along this property line. Here, this is the site plan that's submitted showing the McFerrin and Chickamauga Avenues. The access into the site comes down the alley with a parking lot along the side of the building and a landscape buffer required along this property line here. 10 feet in width is the I'm sorry, Mr. Chairman. There's a 10-foot wide C buffer required along the eastern property line. This is looking at the subject property from McFerrin. This view in the upper left is looking south. Here's the view of the intersection at McFerrin and Chickamauga. These are the properties along Chickamauga to the east and neighboring properties. This is the area in which the landscape variance is required along this eastern property line. As a site plan you see, this upon my visit, it's the parking will come in here, angled spaces to the left, driveway on the right-hand side, and that's where the variance is located. But that's our case record as we have it. If you would please, sir, identify yourself and make a presentation to the board.
Thank you, Mr. Chairman. I think we've had some good discussions, and everybody realizes we're dealing with good faith. Only had one opponent, but the narrowness of the lot precludes us from meeting the condition imposed by the planning department, and thus we're here for some historical context, Mr. Chairman. You know, I've lived across the street there since 2007, and from today to then, while only 4 years in time, is about 25 in progress. And that corner has been stabilized like never before, and it's a principal result of the applicant here commitment to the neighborhood and redeveloping the property consistent with the wishes of the neighborhood. And one of the biggest problems that would be created by the imposition of the condition is the reduction in parking. And if he loses that on-site parking, if y'all will recall when we came here and when I had another life position, that there was some opposition because there was a problem with anticipated parking problems. And as a result, I was a part of the negotiation. We worked with the planning and the code, or Public Works and the codes department, and we put some no parking signs along Chickamauga facing homes, and that was done. And if we had to meet that condition today, it would have a negative impact as far as the parking surrounding the properties, and we would therefore ask that the variance be granted. If any of you members have any questions, I'd be happy to ask them, and the applicant is here as well.
Questions? No questions? Okay, then I guess we'll close the public hearing. Discussion?
I'd just like to ask the,
Urban Forester. Our urban forester and see what he is.
I'm okay with this. I've researched it, I've been out there, and it is very narrow, and it's very difficult to do it. It would mess their parking up considerably. So we're for this.
I think I may only disclose that I am familiar with the property and enjoy being fed there from time to time, but I have absolutely no financial interest in the place.
Well, not a
We'll close the public hearing. Discussion? Oh, we may already be there. Okay.
We already had discussion.
Okay, great. Sorry, I lost track there. Okay, then I tell you the truth, I would like to make a motion that we grant the variance request based on the extreme narrowness of the lot, which forces the parking to run right up to the edge, and given the fact that a landscape buffer would just do more harm to the establishment than not.
Second.
All in favor?
Aye.
Any opposed? Passes.
Thank you, guys. The last case on today's agenda, case 2012-15, Mr. Richard Agabor. Sir, I apologize if I mispronounce your name. My apologies. Is the appellant and owner of the property at 181 Little Green Street, requesting variances in parking, landscaping, impervious surface ratio, and driveway widths in the IWD UZO district to construct a one-story 25, and members, I apologize, I typoed the agenda here. It should be 25 by 80.
25 by 80?
80, yes, sir, not 70.
Okay.
Two-bay building with a paint booth for auto repair use, referred to the board under section 1720.030, 1724.150B, 1712.020, and 1720.060. The applicant has alleged the board would have jurisdiction under section 1740.180B. There is opposition present to this case. I've got some photographs I'll pass to board members when the opposition comes up. But first, let me present our case to the board, and I'll turn it over to the applicant first. The subject property is located on the south margin of Little Green Street, just west of Edgar Street. The Interstate 24 right-of-way is to the southwest of this property. The subject property you see is in IWD, is the parcel bound in red. And the proposal is to construct this building on the property. This would be sort of to the southeast portion of the property. Little Green Street is to the north of this, so to orient you. Little Green here, the building being proposed to be built in this area with the driveway running alongside the adjoining property owner's land. The variances which you see here, this use requires 10 parking spaces. The applicant's proposing 5 on site here. Those 5 are approved contingent upon a variance being granted in the driveway width. Here, the zoning code requires on 90-degree parking a 24-foot wide driveway. Through this area, the applicant's requesting 15 feet in this location at the ramps, and it does broaden to around 22 or 23 feet in this area. Secondly, there's a perimeter landscaping strip required along the western property line of the adjoining property and that's the building which you see here. It has 5 feet in width to run the entire length of that property. They're not showing a plan that denotes landscaping in that area. Thirdly, the impervious surface ratio is it's the ratio of impervious surface to the lot area on this. The maximum allowable, I kind of look at this as more of a green space requirement and take the opposite approach, that they could cover 90% of this site with impervious surface. So 10% of the site needs to be green. Needs to have pervious surface on it. That's the ratio I'm showing you here. 670 square feet is required based upon the plan submitted, showing 515 square feet, 7.6%. So a variance there. And then lastly was the driveway width along this boundary. This is the subject property looking from Little Green facing south, the adjoining residential property. The blue house, which you see here, the owner of that property is present with us today as well. These parcels in the northwest is across Little Green Street on the north side, and then this view is looking west, as you see the car here, looking west toward Interstate 24. I'm going to leave this plan up. As I turn it over to the applicant, I'm going to pass around to the board members photographs the opposition submitted to the record. With that, I'll turn it over to you, John.
Can you hear me now? It's fine. My name's Chet Rhodes. I'm with Rhodes Engineering. I'm representing Richard Abgor, the owner. We'll both be addressing you as we present our case briefly. I just want to go through a few brief things. Prior to Mr. Abgor buying this piece of property, he did do some research, found out it was IWD. His intention is to use this facility for auto painting, auto repair. Paint booth is part of what will be proposed in the building. And so the existing zoning allows the uses, and he ensured that before he purchased the building. The variances we requested, he went over you very thoroughly, so appreciate him putting that slide up there so you can see why we're doing that. It's a very steep site. It's probably sloped 17 to 20% from the top of the page to the bottom toward Meredith Drive at the bottom, Little Green Street being at the top of the site. This site is irregular in shape. You can see the 46 feet basically along Little Green and 50 feet along Meredith. That presents us some challenges. We try to lay out a coordinated plan. Also, the steepness of the site was a design challenge, as well as the narrowness, extreme narrowness of the lot. So for those hardship reasons, we were feeling like the requests were warranted. However, I would want to also point out in our design that Mr. Abgor has instructed me throughout the design process to take great care to make sure that as we fill the lot, we don't impact the neighbor. He's been extremely concerned about the opposition who's here, and they're making sure that we address their concerns in our design. And I think we've attempted to do that, but we'll wait and hear from them. But I do want you to know that our intention is to try to do all we can to mitigate their concerns and listen to what they have to say and try to address them in the design process. I would also point out in our design, we actually provided 8 parking spaces, not 5. That was something that Mr. Hargis said. You see there's 6 spaces on the upper lot and then 2 inside the building. Actually, 1 handicap accessible is in the building. And we've graded the lot so that can occur And so we actually have 8 parking spaces provided in our plan, but we still need a variance because we don't have 10, so.
Can I ask Joey a question while you're, Joey, do parking spaces inside a building count?
Yes, sir, they can. They can. For use like this, an auto service use or like a gas station type use, the point of service can count as.
So where you pull in, that can be considered a parking space, even though it might be where the car is repaired or the car is being painted?
Yeah, this particular use is one of those like auto gas station sales where for that use it counts toward there.
Okay. Well, that brings me to my next point. Let me finish because I got some explanation. I wanted to explain what we're doing, and his question is right on the point that I wanted to tell you. The layout of the building is such that, and the steepness of the lot, we're leveling that lot near the top, and there's the 2 walls that you see beside the building. Those are retaining walls. So the upper lot, we're trying to flatten that out so it wouldn't be so steep. And if the picture showed how this is down on a steep hillside, but by filling in that upper lot, we're basically trying to level that lot so it's a more usable space. The building is down much lower, so that wouldn't impact the neighbors and others as much. The elevation there at 446, and I will just briefly turn on my civil plans to tell you, the elevation at Little Green Street is 465 at the top. You see the finished floor of that building at 446, 20 feet lower. So we're basically anchoring this building in on the lot at the lower side of the slope, and as such, we're going to have patrons parking in the upper lot, but they're going to have to walk downstairs in the building to get to the office, which is just north of that handicap space. So that upper portion of the building will be office space and serving the customers, and the bottom portion of our building will be the repair and painting operations. I wanted you to understand that, and that's why the handicap space in the building, so a patron that's handicapped could actually get in there, be served in the office in that side of the building, and then be kept away from the auto service, auto repair on the opposite side. So we were thinking that through as how we're going to operate. But I want someone to also understand that if you park in an upper lot, you're going to walk down the steps to get into that office because of the steepness of the lot. And I don't know if you could see that from what you're looking at on a plan view, but it's a dramatic effect, and the 2 retaining walls necessary. So we really will not be able to drive from Little Green Street to Meredith across this site. There's an upper portion and blocked off, and that's grass space between the 2 walls, and then there's a lower lot. So you won't be passing through this lot driving through. It's 2 different elevations, and there'll be separate accesses to Little Green and Meredith, and I wanted y'all to understand it. With that, Mr. Abelgor has any comments he wanted to address to you, I just request that our variance request be approved. Do you want to? Thank you.
Can I ask, this is kind of a stupid question, but why this lot? I mean, there are a lot of variances here, and there's 2 levels, and it's narrow. I mean, does he already own the lot? Do you already own the lot? You already own it. Okay. Because
I wanted to follow up on that. When did you buy it?
2 years ago.
And how much did you pay for it?
$30,000.
$30,000. For how big a square footage is that lot?
Less than 10,000.
Less than 10,000.
Okay, so you paid $30,000 for this lot, which I guess, has there ever been anything on this space? This lot?
I think there used to be a building there before,
but not like a business like this?
No.
Okay.
Was it a residential or commercial? You know?
When I bought it, I don't know if it was residential, but I was told that it was a building because I can see the sign of it.
Yeah. I mean,
Okay.
it is already zoned for this type of business.
Yeah. Okay.
Yeah.
It was zoned for.
Yeah. Do you want to answer his question? Why did you buy this lot?
Well, I bought it for my business, auto repair shop. And before I bought it, I went to Codes, and they pulled the place up, and they looked at it, and I asked them because I didn't want to buy it and find out I can use it for my business. When they looked it up, they said yes, it was zoned for the auto repair shop. That is okay. They gave me the go ahead before I bought it.
So what types of tell me about your business. What will you have here? What will you do on the shop, and what kind of customers will come here?
But basically, it's an auto repair shop.
So auto repair, meaning are you fixing like alternators and distribute, or your body work?
Body work.
So if someone gets in an accident or something?
Yes.
So wrecked cars, how do the wrecked cars, because will they be towed here? How do they get here?
Well, some of them will be towed in there and then put in the shop for fixing.
I recently, unfortunately, had to go to a body shop, and my car was towed there, and there was a big lot, and there were a lot of wrecked cars there, to go in there. So, let's say if there's like snow or ice, and you get a bunch of cars at once, where they all go?
Well, we just take the ones that we can. This is a small business, not like the big ones like you see around here. Probably take about 2 or 3 cars at a time, as our space allows us.
But so you turned, like I sent my car to some tow. I didn't call them in advance. I just said, send it over to these people, and they towed it there and they left it there.
No, that's not the way we operate. The owner, we have our customers already. They will have to call us first, and then we see if we have space for them to bring it in. If there's no space, they will not bring it in. So there has to be a pre-arrangement.
So you have 8 spaces, including these spaces inside?
Yes.
And so how many cars so you normally work on 2 cars at a time?
2, 3 cars maximum,
And when I don't know a lot about body work, but when you paint and do all the curing and all that, other people can't be inside the building when all that goes on, can they?
Yes, they can.
They can?
Yes.
Okay.
We have an office where the customer sits and wait if they come,
Okay.
I guess I'm curious as to why, as tight as this building is to that site, if you're using 2 spaces of parking inside the building, why didn't you just make the building a little smaller and put the parking outside?
He's got to work on the car somewhere.
We have to have
You can't work on a parking space or required parking space.
He needs 3 bays inside to work on them.
The answer to your question is,
It's for working.
Excuse me? That's my
you want me to answer that?
We are required to have a paint booth, and that paint booth is about 15 by 30, 25 long. Even though I'm not using the paint booth because I already have a contract with Econo that paints my car for me, but by state law we have to have one there, and that takes space. And then part of the variance is for me to have 2 bay garages, because I'm going to have a frame machine that straightens the cars out when we bring them in, and that takes space. And then the office on the left side, that's going to take a little space. That's why I want it wider, so we can have enough room to work on.
But, I think what we have is a workable plan that addresses his needs, and also we try to get as close to the parking requirements as we could. So in looking at the requirements, we've come up with a plan that tried to address as best we could, and also would say staff, Richard Thermopolis in particular, has helped us guide us through what we should be doing. And so many things that you see here are recommendations of Metro staff as we try to develop this site. So thank you.
Let me ask you this, and I know we're going to hear from some neighbors, but you'll be fixing wrecked cars. Not the most beautiful sight to be across from, somebody's car that's all beat up. You don't want to have the landscape buffer? Why not?
Well, let me address that by saying we are putting a retaining wall at the property line.
No, but we're talking aesthetically.
No.
That's the reason why we require that. And this is the kind of business that, for the benefit of the neighbors, we don't want them looking at wrecked cars or whatever. Yeah. And so that's why that's required. And you all want a variance from that.
Yeah, but we are trying to put a barrier so that they won't have to see what we're.
But that's not a landscape buffer.
I know, but it is trying to address the whole comment you made about them not wanting to see those things. We are trying to address that by doing that. So
is that in your plan?
Yes, it's on the plan. Retaining wall on the property line.
And how tall are these retaining walls?
They're several feet high. I'll have to look. It varies as you go. It's a steep slope lot. Mm-hmm. It's 3 to 5 foot stair step down the hill. in various places. So
We just had a pallet case, I know you sat through, and so with this wall, would you be able to see any of these cars?
It will block view of most of the activity on our site from their residents, so they wouldn't have to see it.
You say most, where will you be able to see?
Until it's finally constructed, the certain height of the wall, they're going to be able to see the roof of our building for sure, and some other things.
I'm not concerned about the roof of the building. I'm concerned about seeing a wrecked car that's kind of sitting on the property waiting to be repaired.
Well, the wrecked cars will be coming in off Meredith, tucked down there, so they should be pretty well protected from sight with that
There's
wall.
a difference between pretty well protected and protected. I could speak from experience.
We've done the best we can to try to address that, so I'll just leave it up to y'all's decision, but we're trying to make it, 4 or 5 feet high. That's what we're doing. I'm trying to explain to you what we're doing, so.
Okay.
Mr. Chairman, can I clarify something? Mr. Ewing's question was about parking. No, this particular use, the 5 that you see up there, the ones inside the building, we are not counting. This is not one of those uses like I was describing, so I didn't want to mislead you.
So the variance is still for 5 spaces?
Yes, sir, it is. The ones inside the structure we can't count. That's the 5 which you see on the north side of this parking deck area up here.
Okay, thank you.
Do we have any other questions for the applicant, or should they save their time for rebuttal? Okay, why don't you save your time for rebuttal? Thank you.
As these folks depart, if anyone wishing to address the board want to come forward.
Okay, if you'd like to introduce yourselves. And
my name is Bobby Jocelyn, 630 Murfreesboro Road, Nashville, Tennessee, 37210.
I'm Jerry Hunter, 173 Little Green Street, Nashville, Tennessee. And the first thing I'd like to say is I've lived there 45 years, and I hadn't found Meredith Street yet. The street he's talking about is Old Plain Street. It's cut off by the interstate. My house is the only house down there. There's no way to bring a car in out of my driveway up there after they put a wall without getting on somebody else's property. There's just not enough room for it, that's all.
Mr. Chair, members of the board, I have developed, I own about 13 or 14 lots in that area, all of them commercial warehouse buildings. Actually, my nephew bought this lot against my judgment about 10, 12, 13 years ago when I told him, don't buy the lot. It's going to cost you a fortune to try to build on it. And this is surprising to me that wall probably in the very rear would have to be probably 15 or 20 feet in the air. Mm-hmm. And I don't know how you'd ever bring a wrecked car in there with a wrecker and even think about getting it inside the building. I've been before this board on other occasions. I've never been before this board on any of the dozen warehouses that I have built in this area. I've never applied for a variance on landscaping, parking, setbacks, and you have to make your warehouses, your buildings work with the neighbors. This will not work in any shape, form, or fashion. The only thing that would actually work on this building would be a real small little building up on the very front where it's level. And I mean, it is a horrendous drop-off. And I mean, to come in and try to stair-step a little lot like that even shocks me, because I would never dream of that, because you still really don't have good access on the bottom side of that. So I would recommend that the board disapprove all of these variances. We've worked hard in that neighborhood. There is residential on both sides of this. And it's turned into an industrial area. And I'd like to see more industrial warehouses come in there, but I like for them to be, I like for them to blend in with the rest of the neighborhoods, because we've done a real good job. These folks have worked real hard to try to keep their properties up, and they've called on me to help them on different obstacles that have come their way, and I really would like to be here on behalf of them as more so than I would myself to protect their interest.
I'd like to say, when I moved there, I couldn't even get to my house. I used my own equipment, cleared it, paved it, and it's decent now. Like he says, the neighborhood, it's a nice neighborhood now. We worked for years and years.
Jim, can you put the aerial photo back up there? Which one is your house?
What do you say?
His house is down at the bottom to the left. Keep on coming down the rear, down one more right there.
Okay.
That's where he lives, right there. It's a dead end. You can see it's kind of a little curve coming out, going in and out. It's very narrow. I mean, that around that curve up there, you can actually see that. It looks like it's only about 15 or 20 foot wide. The landscape, I mean, I've landscaped all my warehouses down through there, and I think that's part of what we do, is to try to make a neighborhood look better. And a retaining wall by no means is a landscaped area, unless maybe you want to paint it green or something.
And where are your warehouses relative to this?
Actually, to the left, beside that billboard there, across the street, that one. The one next to it left, the one across the street from those, come back to the right, both of those, and then there's a couple more down in that area as well.
And as you said, you've never asked for a variance from this board to operate any of those from a parking, landscape, whatever, driveway would?
I built a 2,400 square foot building on a 32-foot wide lot without any variances whatsoever. And I met my handicap, my parking, and my landscape.
I'm not a real estate expert in this area of town, Mr. Jocelyn, but the person bought it for $30,000. What would you say in response to someone paying $30,000 for that lot?
That's why that's why he got it for $30,000. My nephew bought it, I think, for $6,000, to give you an idea, and I tried to talk him out of that at that point in time.
I think if you'll check under that very lot are sewers.
Oh, I don't have an idea. Up to the right is another vacant lot. You can see, looks like a dump truck or something. That gentleman to the right, keep on going over just a couple more. One more right there. That lot is for sale. It's pretty flat. It's a very buildable lot. You won't have to have a variance one to go into that and build something. I think the guy's asking $55,000 or $60,000 for that lot, to give you an idea of what we're talking about. You get what you pay for is about what this boils down to.
Yes, sir.
So just so I understand what they're trying to do, on the lower side, and I can't read the name of the street. On Meredith, that's where the building is they're proposing to be. So anytime a car was towed or driven in to get to the base, it would have to come down Meredith Street.
That's correct. Yes.
And then anybody who was coming to park to go to the office would come through Little Green Street. And there would be a two-tier. Okay.
Exactly. You're right on.
Sir, excuse me. Meredith, as they call it, is my driveway. I've never heard of a Meredith. It used to be Fane Street before the interstate cut it off. And you come to my house, it's dead end.
Okay. Yeah, I remember you telling me that, and I didn't make the association, but now I see on this map what you're talking about.
Yeah, there's no way to get off of that driveway onto that.
I'd say the back of that building would probably be somewhere around 40 feet tall to make that work. Yeah. And the drive, they didn't mention anything about the driveway going in. I don't know how you'd go into a building with a driveway going down in a level building. I just don't. I don't know how that would happen.
And when you're talking about that 20 to 40 feet, you're talking about to level it to Little Green all the way? Okay.
Yes.
And, I mean, they're proposing a tier, which is a strange, I mean, it was not strange, it just, it is as Chris Wilson said, it's, why this lot, to have that much of a variance between the front and the back and customers, all that. It's just a strange place to try to do what's going on.
Yes, that's
But I
exactly-
just want to say, but you're saying to level it to Little Green is about 20 some odd.
I'd say probably about a 20-foot drop-off. Again, a wrecker's probably 16, 18 feet. You're going to have a 16, 18-foot car behind it. Can you even go in a 20-foot wide area, approximately 25 feet max, and even bring a vehicle in it? And then again, where do you put your wrecked vehicles? They're going to pile up somewhere. It's just bottom line.
I'd like before anybody made a decision on it, I'd like for you to go out and look at it. But if you see what it is, then.
Who is in the property between the proposed property and your property?
These two folks right here.
Right over on, I've got a corn lot over on, right where the driveway come down to. And then where the alley come down.
Wait, I'm sorry, sir. You need to come up and introduce yourself if you would.
Scoot up.
I'm Burley Johnson. I own lot 183, right in between.
Is that your house?
Yeah,
How long have you lived there?
almost 20 years.
Okay. And so why don't you want this across the street from you?
Well, I don't think he'd have enough room, and then like I said, parked over and broke down cars and everything, and probably make the property place look like a junkyard if you get parking them around, out on my fence side and all that.
Actually, Mr. Ewing, the gentleman owns the house to the right of the rear of the property, to the right. Back in there, that's his home right there.
So he would be looking at the
He'd be
lot.
looking at the 20-foot wall.
Okay.
Amen.
This lady lives.
Oh, is the button punched? Okay, you know where just about that I live there, and that lot is.
State your name, please.
Oh, sorry, sir. My name is Mary F. Kessler, Kessler.
And where do you live?
179 Little Green Street, right next to the lot. That's my house there.
Her property joins it.
And that picture right there, it's flat.
So why are you against this?
Sir?
Why are you against him having his business
Well,
next
he's
door to
been
you?
very hateful to me, and he slapped my fence and told me he's going to for me to take it down. Then he told me he was going to put the dirt to the top of it.
Okay, but I'm interested why you don't want him to have the use of a car body shop next to you.
I have asthma, bronchitis. I have a diseased heart, and I'm a diabetic, and I just don't think that would be healthy for me.
Do we have any other questions for the opposition? Doesn't sound like it. Thank you. Would the applicant like to exercise their right at rebuttal?
Thank you, sir.
Thank you.
Appreciate you having us.
Well, first of all, I want to tell you there are no 20-foot walls on this site. As designed, I think the largest retaining wall is 4 to 5 feet high. We're grading down the lot as we go, so the upper parking lot sloped at 7% as it comes this way. It's not completely level. It's just leveled compared to the steep slope. So it begins to drop down the hill, which allows us to have two intermediate retaining walls that are moderate height, 4 to 5 feet each. Also, the back of the building serves as a retaining wall on the right side. There will be backfilled material against the building on that, so that does act as a retaining wall. So the comment about 20-foot retaining wall, there's no retaining wall here over 5-6 feet tall. So I want you to understand that. There was a lot of concern by the neighbors, which we appreciate, of how we're going to get in and out of there. But I want to assure you, the Metro staff, the Stormwater and Public Works people have commented on that. We've addressed their concerns. We have adequate access in and out for our purposes. And I have a grading plan here with me, C3, that shows the grading proposed, so you can see how they can get in and out and how that would work, because that was a concern that they brought up, and it was a concern that I had when I began working on it. But I want to make sure it functions well, and as the engineer, I can tell you they can get in and out of this lot as proposed, and it is a legitimate concern. We want to be able to get in and out and have a functioning, well-run business here. As to the comments the lady made concerning her health, I know of no activities on this site that would worsen her health. And so the last final comment I would have is that Mr. Ewing had concern about the landscape fence and things. We'd take a conditional approval with whatever height fence he thinks is appropriate between us and the residents to the east or south of us.
I didn't say anything about a fence.
To the west, I'm sorry.
I was talking about a landscape buffer, which you're asking for the variance on.
Right, that's right.
Why don't you want to?
So the landscape buffer we don't want because of the extreme narrowness of the lot. The irregular shaped lot, you can see it's 46 and 50 feet. So both those present hardships, which are things that you would look at when you come to this committee. And the third was the steepness of the lot, but we're trying to address that with the retaining wall. So
I understand that.
So I'm answering your question, why we want that.
The reason the code requires the landscape buffer is the type of business that you all are proposing is not aesthetic for the neighbors. And they might have to look at wrecked cars outside their houses for long periods of time. That's why a landscape buffer is required. And you're saying you don't want to do that. You'd rather put up a wall, which I asked you, could you see any of these wrecked cars? You cannot tell me definitively that you could still not see the landscape, these wrecked cars, even with this wall.
Well, we're willing to raise the height of a wall on top of a concrete wall with a wooden fence on it to a certain height. If y'all want to specify that to whatever y'all think is suitable, we're trying to keep it 5-6 foot, a normal height of a normal fence. So, it seems I can't fully address his concern, but we are attempting to address all concerns that we've heard. And so I guess I would leave that matter in your hands, but I would say that this was zoned IWD by others, and so the use that we're seeking is not something, we're not asking to change the use.
I haven't said anything about the use. I'm saying something about the variance that you're requesting. And while we're down that road, let's talk about parking.
Yeah.
You are asking for 5, Joey says that basically the spaces on the inside do not count. So the code requires 10 parking spaces. You are only offering 5.
Well, we've provided 8. He's not counting a few, but we've tried to get as close to 10 as we could.
Guess what? We're listening to him.
Yeah, I heard him, and I accept that. So I'm not arguing that point.
So you are asking for 5 spaces then?
Yes, we must, based on what he said. So that is what we're asking for. But I'm not, anyway, I hope I answered all questions. We don't want to be argumentative. We're just trying to make our request clear. Appreciate your time. Yes, sir.
I just want to make a few comments. Before I bought the land for the business, I drove around that area to see if we have any other business just like mine in that area. And if you can pull the picture up of that area, I can show you that we have it.
I'm sorry, continue.
Can you pull the? Yes. Okay. If you look on the right side, yes, that's a car lot right there. And sometimes you can have about 10, 15, 20 cars parked there, some of them accidents. And that car lot has been there, I don't know how long, probably years. And the neighbors know about that car lot. They never made any comment about that. And if you go across the street on the other side, There's a mechanic shop there. Yes, there's a mechanic shop there, and if you go there right now, at least you will not see less than 20 cars parked around the building. So, I mean, mechanic, body shop, car lot, they walk side by side. If you go across the street on the other side, there's a big body shop there. So it's not like I'm bringing a business in that does not fit into that area. I mean, this is a small business of my cars. I don't sell them here. When I buy them, I fix them and I ship them overseas. I'm not going to have more than 2 or 3 cars at a time. But I already bought a place, and $30,000 is a lot of money. And that's my life savings. I've been here 20 years, and that's everything I have that I put in there. You know, I'm 50 years old. Nobody's going to give me a job now to hire me to work for anybody. This is my dream. This is what I've planned with my life, and this is what I plan to do. And for anybody to come here and stand against me saying that I can't, get what I've worked for all my life is not fair,
I personally commend you for that. I guess my concern is, it looks to me like you're trying to put an awful lot of building on a small property, and that's why you're having to ask for so many variances here. And I said a little earlier, maybe if the building weren't quite so big, it may not serve your needs. But should the city or the neighborhood sacrifice to grant so many variances to accommodate too much building on the property? That's my concern.
To piggyback on what Mr. King said, if you're not going to use a paint booth and you have somebody else doing your painting, why are you having to install a paint booth? I did not understand that.
If we have to have a body shop, the state required us to have a paint booth there. Whether we use it or not, doesn't matter. We have to have one, because when code come for inspection and they know we are using the place for body shop, they will ask us, where's your paint booth? Because they know that after you fix a car, you have to paint it. Whether you take your car somewhere else to paint, they don't want to hear that. They will give you a citation for that.
Seems the variance needs to be on the paint booth and allow them to put a landscape buffer in there.
I mean, if you want to add that to it, I'll be glad to take that one off of it, because I really don't need the paint booth.
Seems like extraneous expense if you're gonna outsource your painting.
Yes. Well, it's cheaper for me to outsource it than putting the paint booth there.
That's what I'm saying.
But I'm just doing what the law says. That's why I'm adding that to it.
Can you help me
Do
with
we
this?
give paint booth variances,
If
Joey?
he's not going to use a paint booth, why is he required to have one?
That he just testified that is the state's requirement. It's not a zoning.
Is that the case?
Code. It's metro code, not state code.
It's codes.
Yes, code.
Is that a codes requirement?
I'm not familiar with that requirement for the zoning code. There is none.
Can we give Can we ask our lawyer? Can we give a paint booth variance?
You can ask. I'm unfamiliar with any paint booth variances or paint booth law as would be applied under the Metro Code.
But let's assume that this law is required that if you do have a body shop, that part of it has to be dedicated to a paint booth, and he's not using it for paint. Could we, as a board, say he doesn't have to have a paint booth?
I'd love to be able to give you a definitive response on that, but under the state code 137208, where of course a lot of your powers originate as a board, certainly that's not something that is specifically enumerated, and I'd have to see if even the broad brushstrokes that are given to the overall powers this board has would be broad enough to encapsulate that sort of specific request, and I'm afraid I'm just not able to opine on that definitively at this point.
It seems to me if we can help him with this square footage issue about a space that is absolutely vacuous in his building, he can give up some of these issues on the variance. I mean,
Potentially.
I respect and I want to commend you, as I love to see an immigrant have a dream and to make something great happen in his life, and we want to see that continue and not be a barrier to that. But we certainly respect what the neighbors are saying, and I think if there's a way to provide landscaping and to do some of these things, if we can deal with the issue of the square footage that is going to be unusable anyway, if there may be a compromise that's settlement. I think there's some unanswerable questions at the moment. Is this an option that can be discovered, or is this just not to be dealt with?
No. The applicants raised this. I asked the applicant to point to the code section that says you're required to have a paint booth. Can you point that out to me? Because it's nowhere in any book I have.
Well, I have a lot of friends who have body shops, and they are made to provide a paint booth in their shops.
If they're painting, but if you're not painting, why are you having to have a paint booth?
That's a good question.
Did you just listen to your friends, or did you get some definition to that?
Oh, I just listen to my friends because most of them.
Okay, I think you're getting bad information. All right. I think there's a whole lot more to this, and I think this is really in your engineer's hands to do some investigation about this. I would hate for us to stand here and make a decision that would kill your opportunity to do anything if this was an actual fixable issue. Is this something that you still want to move forward with if there's an opportunity to correct the problem?
Well, while you were talking, I do want to maybe suggest that we defer it 1 month to get the opinion from the attorney. And if we are able to remove the space for the paint booth, then we could bring back a slightly revised plan and try to further address things. But, if we deferred it to them, we could get a definitive answer and we could see if that is an opportunity. I think that'd be better than taking an up or down vote from what I've heard here. So,
how much space does this paint booth take up anyway?
that is, that's going to be an operational question on his end because all the area inside is not defined yet.
Is it 200 square feet? Is it 500 square feet?
Well,
the
whole building is only
15.
Just one.
15 by 25.
Okay, that's a lot of space.
And you can't use it for anything else?
That's 375 square feet.
Okay. I can't use it for anything.
This may make a significant change in how this building needs to function and being able to appease the neighbors and make this a great compromise. And I think it's just a good recommendation on behalf of your client to give him an opportunity to verify through you what's required. I hate to see him throw his money away on something that is his dream, but I also have a hard time even considering that there's another opportunity here. If you all are amenable to him doing the right thing for the neighborhood in addition to what's going on, I think we can have a great compromise that would work on everybody's benefit.
Yeah.
Do you see that?
Yeah, I have a question to, I guess maybe to Joe or Linda. If we do defer this and then we make a revision to the plan, what are our submittal and application requirements? We're going to have to go through all that again because there's a whole lot there. Or can we just not submit the revised plan to you all? I'd like some clarity on what our obligations are for, work.
If the board defers it, you can submit a revised site plan to the board showing your amended site plan, which they'd get a copy of. I'd ask you on the procedural end, rather than take a friend's advice, if you could point to a code section where this paint booth's required, it would be the first time I've ever heard of. But if again, they've got to make that decision whether they're going to defer or not, or vote this up or down today. But you can submit a revised plan if it's.
So assuming the paint booth is not required, would you come back with us with a smaller building footprint?
Yes.
How much smaller?
300 square feet?
307. At least 375 square feet.
I mean, I think the discussion that the neighbors are expressing is a very viable one. And if there's an opportunity here for everybody to live in harmony, it should be explored.
Yeah, and I do want to say, I know Mr. Abigor, I've worked with him, he's expressed, to me that I'm to do all I can to address their concerns. So That's the instruction I've had from the owner. Thank you.
Yeah, and if you, I don't know, what was submitted to us was just kind of the site plan. If we are able to get copies of, a bigger set, that would be really helpful because it's difficult for me to understand the slope, the drop,
Let's look for some
what the impact is, how big the retaining walls are, and when and again, it's not my piece of property, it's not my investment, but retaining walls are not cheap. And so I understand if you start building a whole lot of retaining walls, even 5-foot walls, all around the property, all of a sudden that other piece of property that was mentioned earlier looks pretty attractive. But, and again, I know that's not your option, you bought this piece of property, but I would like to understand more than just in this dimension through the other sets that you have, exactly what we're talking about when you come back to us, if you could.
Mr. Hargis, for this submittal, the site plan only was required. I do have a grading plan with me. I'll be happy to share with it. Anybody wants to look at it after the meeting to see how those grades are being accomplished. Thanks.
Well, and I think when we all make a decision, we want it with full information.
Well, I'll do that, submit that.
Yeah, that would be
but-
really helpful because,
Sure.
we've heard about street names changing and so until we saw it and had everything pointed out, there was a little, I just want to understand where everybody is.
It'd be helpful for you in your case to help us see what's going on.
If you want to see what we have and how we made this work, I'll show you that, but obviously that'll change slightly from what we're talking about. Thanks.
And again, my logic was simply to get more near the compatibility of the size of the lot so that some of those variance requests could maybe go away. That's my concern.
So we'll defer this 1 or 2 meetings and put it at the top of the agenda?
But if memory serves, we have a meeting in 2 weeks, but we don't have one in a month.
Correct.
So I think we're putting it off 6 weeks probably. I mean, well, two meetings. I mean,
Would that give you ample time to make the corrections to the plans and then resubmit? 6 weeks?
How much time is it going to take you to give me an answer? Because I'm going to have to wait on that.
Well, no, I want to get that out of the way. Our board's attorney is not looking into whether we can grant a paint booth variance, because I'm going to tell you on the record, there's no such variance to be granted. So I'll save John Michael the looking.
We just assume that's gone then, okay.
I would ask you, if your client's sitting here saying, I must have a paint booth, have him provide the code section that specifies that and bring that back to the board. And then, but this board's only tasked with granting what's in the zoning ordinance.
Okay, thank you.
And that's not here.
So the 16th or the...
okay. So we're going to, a motion to move it to our first meeting in March, which is actually in the middle of March.
It'd be March 15th, Mr. Chairman.
Okay, March 15th. Thank you.
No, they're formally requesting deferral.
Yes, they are requesting, and so I think we're. Okay, so they're requesting, and we are going to put them at the top of the agenda. And should we rehear the whole case because we're missing 2 members, and I think we should.
Yes.
Yes.
I agree.
Make it as if it was a brand new case.
Because it should be a brand new plan.
Yes, I agree.
Am I paying another money again to?
No, you want, well, I don't know, maybe I'll
I don't know, Joey,
defer to Joey. They're not paying a new filing fee, are they? Thank you. No.
Thank you.
Thank you very much.
We are adjourned.